No, we're going live. Good morning, everybody. Welcome to this special webinar that we're hosting on the Property Law Line. Joined here with Phil Mao and Greg Mark. Welcome, guys.
There you go.
Thank you. Good morning. Sorry to have made you all wait.
Great. Sorry, that was a bit of a no problem at all. I mean, it's true government fashion having to wait just a little bit for the good stuff. So obviously this webinar is on about the special regulation that was given last night, allowing people to move between their residences. So we just wanted to discuss this and see the actual impact of this regulation on the property industry. First things first, what exactly does this regulation say? What does it mean? Are people allowed to move between houses? What is the exact impact? Silna, do you want to maybe take this one?
Yes, so I will specifically refer to the regulation. The regulation specifically says that people are allowed to move, the movement of a person and goods where a new lease agreement were entered into before or during lockdown, or the transfer of immovable property that occurred prior to lockdown. So I think very important to note here is lockdown is defined in terms of the regulations. Lockdown is defined as the period of 26 March until 30 April. So when we talk about lockdown, very important to know this is the time that we are referring to. Then the regulations makes it wider. It says for people to move within or across provincial, municipal, or district lines. So what we are saying is people are allowed to not just move from one province to another, they are also even allowed to move within a district, which will mean I can move pretty much to the house next door or in another province. Movement is allowed, and with that, moving companies, the regulations refer specifically to regulation 22(1)(f), which allows for moving companies. So it doesn't have, you don't have to move anymore with a bakkie and two people. You can now call a company to help you out with the moving. Guys, am I warm here?
Yeah.
Yeah. Okay, fantastic. Then, so people are allowed to move. What is the standing with ingoing and outgoing inspections now? What are agents and tenants and landlords allowed to do? I don't know, maybe Bruno, you want to take this one?
Sure. So look, as far as we're concerned, the job of an estate agent or the job of an owner in terms of the Rental Housing Act, for example, requires that certain inspections be undertaken before people move into the property. This is a necessity for lease agreements because you don't want those disputes to arise at the end. All our viewers know this. So now the question arises as to whether the owner himself or herself has to do the inspection or whether an estate agent could be appointed to do the inspection. Our understanding of this is due to the fact that we're looking at social distancing and keeping people away from each other, whether it's the owner or the estate agent makes very little difference. So in our mind, the job of the estate agent has now been permitted for the purpose of this these particular directives. Unfortunately, it's not very clear from the directives, so this is very speculative, but we're leaning more towards it being allowed than not being allowed.
Yes, Bruno, last night I still said to agents asking me this, I said we're going to have to figure out how to do virtual inspections. And I was very much convinced that I don't think agents can do the inspections, but sleeping on it and thinking about the logistics behind it, the type of disputes, the unintended consequences that we're going to have to not comply with the Rental Housing Act, so not to do the inspections, or to let landlords and tenants do the inspections where they specifically instructed an agent because they don't know how to do it. I must say, I think it's grey enough for agents to attend to the inspections, as long as obviously they comply with all the regulations, PPE, social distancing, the whole thing. I don't think it makes sense to not do the inspections, or let the people that doesn't know how to do inspections do the inspections, as long as it's safe. I really believe that.
I agreed.
Sonal, do you have any particular safety measures for agents to make sure that the inspections are regulation approved?
Yes, so obviously very important, gonna have to wear a mask. Everybody has to wear everybody has to wear cloth masks, face masks. I think you're allowed to wear other masks as well, but at the very least a cloth mask. So wear a mask. Obviously keep social distancing. I know we're saying 1.5 meters, but I would recommend 2 meters at least. You are in the same premises, so you are close to each other. Keep a safe distance. I would even recommend that the one party stays potentially outside. One goes through the property, make notes. The other one goes through, compare notes, and only when there's an actual issue, go to that. So stay far away from each other. If you have a temperature of the other party is spiking a bit of a fever, don't come close to him. Rather than make another plan. But make sure that nobody has a fever. Everybody is under 37.3 degrees Celsius on themselves, and wear masks, and obviously wash your hands until your cuticles start losing focus.
What's quite interesting is they obviously haven't specified in the directives any more than that. So what Silna is actually mentioning now is good practice. It's logical. And something else that also sounds very logical to me is, for example, if you look at the workplace regulations requiring sort of the cleaning of the workplace, something like this, in my mind, would necessitate that. So, for example, a landlord that has an outgoing tenant and a new tenant coming in, make sure that the place is also, there's a level of, like, it's a deep cleaning. And then exactly like Silna said, the actual inspection itself, social distancing, masks, you name it. Try as much as possible to not have to interact, but it's not always going to be possible. But at least make sure that the place is fully cleaned. Whether there's a need to screen people, I doubt. I don't think that obligation will be placed on anyone. But like she mentioned, if there's a fever, be careful. It's definitely something to worry about.
Sure. And then while obviously we're on inspections, ingoing, outgoing, what does this mean for people who actually are going to move? Are removal companies now also permitted to now work and assist them? Cleaning services to get into the premises to clean before the next tenant is able to move in? What is the standing on those? Greg, maybe you want to.
Look, let me say, when we started this alliance, obviously the three of us do different things. My two colleagues are much more involved in the property industry per se. Let me say on this point though that we started picking this up early yesterday evening. I phoned a friend of mine who's been unable to move, and the moving company had already phoned him 20 minutes before to say, right, we're on. So the answer would appear to be yes on the moving company. And I think cleaners, I don't know what their level 5 status was, but I think anyone delivering a sanitizing service, I think is on. So so in that context, I think I can safely answer those two questions in the affirmative.
Fantastic. Then obviously the regulation specifically says that lease agreements entered into before the 30th of April. So are only tenants allowed that have entered into lease agreements before the lockdown or before 30th of April allowed to move now? What happens to tenants who have entered into a lease agreement or wanting to move now after 30th of April? What does this mean for them? Silna?
So this is a very interesting thing. The regulation specifically says a lease agreement entered into before or during lockdown, or a property that was transferred prior to lockdown. At least at this stage, we have certainty that the deeds offices aren't open yet. We got a directive this morning at 2:10. Did you guys see that from the Legal Practice Council? And the last point was we have no clarity on when the deeds offices will start functioning. So at least we know for certain that we won't be able to transfer anytime soon. So we only refer to transfers prior to lockdown. But it says lease agreements concluded before or during lockdown. So the truth is, nobody actually physically signed lease agreements during lockdown because nobody knew they would be allowed to enter into new lease agreements. You know, we've been saying constantly for the past 7 weeks, do not move. Nobody is allowed to move. Don't move, don't move. And suddenly we're saying, okay, go, 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 guys, go, 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 move before the 7th of June. So, whoa. So I think a very important point to make is, remember, guys, lease agreements doesn't have to be in writing. So the landlord and the tenant that entered into conversation, potentially even concluded a verbal agreement, to the point of at least discussing which property we're talking about, sort of the amount of rent you are talking, that could be seen as a valid lease agreement, albeit verbal or even still in negotiation phase. If that lease agreement is now reduced to writing, so the agreement was concluded during lockdown in a verbal way, if that agreement can now be actually reduced to writing because the parties are allowed to move and interact a bit more to sign the physical lease agreement, I would just recommend that the date that is recorded in the written agreement, it then does reflect the time of the negotiations, which should be prior to the 30th of April.
Agreed. Can I ask a question, Rowan, through you?
Yes, absolutely.
The deeds office,
very different, but yes.
the deeds offices are entitled to open; they just haven't opened yet. Is that right?
Yes.
So I've been engaging with the rental housing tribunals, and what they've been doing this week is meeting to set up their systems. So I suspect that all government agencies, much less pressured to be open than non-governmental businesses, have spent this week working out how they're going to do it. So we would anticipate, the tribunal was saying, I doubt it will happen now, that they might be up and running as early as Monday, but it may be next week. I suspect the deeds office and other, I don't know, maybe master's office have been doing the same thing. So we could see the deeds office open within a week.
Yes.
Okay, good.
Because they could, they were allowed to open Monday already. And they just, so as soon as they have PPE, that's the issue with the deeds office. They don't have PPE.
And that's not all.
Okay, I've got a question here. It says, what about a moving out inspection for someone who moved out just before lockdown, but handover inspection was not conducted? Can this be done now before the 7th of June? Would that not be that you would be able to do the handover inspection as long as you're following regulations, keeping social distancing? That wouldn't stop you from doing so. Is that correct?
I would say the thing is, the longer a property stands vacant and an inspection is not being done, that is to the prejudice of the previous tenant that moved out. Because theoretically, if the one tap now starts leaking and causing damage to the property, it will be then on somebody that didn't actually cause the damage. So in compliance with the Rental Housing Act, I would definitely say I believe people can do inspections when they follow the necessary safety requirements.
See, my only potential worry with that is, if we're looking at the purpose of the directives and the regulations, I'm worried about an argument to say, look, the thing is, the focus isn't on necessarily just inspections. It's about getting people to move around. A byproduct of somebody moving is the need for an inspection for that person moving in. But for example, someone that's already moved out, doing an inspection now after the fact, I agree with you. It's definitely something that's necessary. I just don't know whether it falls within the narrow ambit of what the directives are really trying to achieve. It's possible that it does, but I think I would maybe approach it with some caution, just in case. I don't know if we'd be able to sell that as strongly as incoming inspections.
Yes. Yes, I agree with you, and I think it's a very the problem that we faced with is if we are wrong in this, and we say people can inspect in that particular situation, and we get it wrong, we're going to send people to jail for 6 months, and that is obviously not our intention. So I think for safety's sake, Bruno, wouldn't the solution be to go to the police station and not like a permit for moving, but just verify that in a way? I know it's going to be a very unnecessary effort, but just for safety, I don't think there's too many of those cases. So in that situation, maybe just verify, because until last night, the police didn't have the right to give these permits. We now potentially they would be able to, just for safety.
No, absolutely. Just for safety. I mean, if you have it, at least you're covered. Even if it's technically not allowed or whatever the case is, why not?
Exactly. Then Greg, I'm loving your face on this one, because we all know that it's going to be very impractical to go to the police. But yeah. I will just appreciate what I can see you thinking right now.
While we're on the,
I don't play poker.
You shouldn't.
While we are on the topic of not poker but the permits, what permits? What does the person need to do to get this permit? What is the exact process in order to make sure that they are allowed to do so? We've got quite a few questions just to say what documents or permits are required for a tenant to move between these dates. Silna or Bruno, maybe you want to. What is the exact process for these tenants?
The permit is actually, the form is attached to the regulations. So Rowan, maybe you can just we can just post the full regulations on the group.
Sure.
After this, we already posted it last night, but just to post it again, if you open the regulations, you will see the form is attached to that. So basically, it's as simple as printing that page. If you can't print it, rewrite it. If you don't have a printer with you, go to the police office. Police will stamp. It's the station commander or a person that was instructed by the station commander to act on his behalf. Simply stamps that permit, and that is it. So the form is actually in the regulations, so we don't even have to try and think what it should be like. You print that and that's it.
And that's it. Pretty simple and straightforward. Then also, so for instance, this regulation specifically allows for lease agreements that were entered into prior to lockdown, prior to 30th of April. Now, a lot of questions are, what about tenants who've been given notice to vacate the premises, or the lease agreements have been cancelled beforehand? Now they're sitting in the premises, not paying rental, and not moving out. What would your advice be for these non-paying tenants?
Well,
Silna.
Should I jump?
Yeah, I don't know who
Sorry,
wants to take this one.
Greg, you're the one for this one.
What we've been doing in lockdown is, if we terminate someone's right of occupation, we advise them that we're proceeding with an eviction application, because they become unlawful at that minute, and the only person, in our view, who can truly decide if someone's occupation is unlawful is the owner or lessor. So what we have done, and it obviously is an aggressive move, is, okay, unless you pay by X date, we will terminate. If we terminate, you become unlawful, we will commence eviction proceedings. You know, fairly safe, I think, in the understanding at the end of, by the time the proceedings end, because they're not short, we will be able to physically evict someone if they don't vacate as ordered. So that's how we've been handling that.
Okay, fantastic. Then would that also be a similar situation to, for instance, people who have, during the lockdown, lost their jobs, they cannot pay the rental, as well as people who entered into a lease agreement before the lockdown, and now because of this lockdown have now want to now pull out of the lease agreement?
Yes, okay, so that's two separate questions. I must say, to add to what Greg was saying, is the person who was placed on terms and we've cancelled the lease agreement because he hasn't been paying his rent. That person, remember, as much as the regulations are saying that it's a lease agreement or a sale, this person can definitely now find alternative accommodation, be it in a residence that is available to rent, so a reduced rental. Once again, make sure the lease agreement is dated prior to the 30th of April, because in fairness, this person would have tried to move, but he was waiting for these regulations. So the truth is, the practical application on that would be that the date on the lease agreement will have to be prior to 30 April. But remember, somebody that's in illegal occupation, no landlord has an obligation on him to provide free accommodation to any other citizen. Simple as that. The fact that it's not nice to move in with your mother or your mother-in-law doesn't mean your landlord has to give you free accommodation because you want to not live with other people. So the person who hasn't been paying rent, even unfortunately the guys that couldn't pay rent because they lost their income because of COVID-19, we can't put the obligation on the landlords to provide free accommodation for these people. It's heartbreaking, I get it. But unfortunately, it's equally heartbreaking for the landlord having to service his bond, pay rates and taxes, and have somebody in the property for free. That tenant that's in the property, as heartbreaking as it is, will have to downscale, either move in with friends or family, and the regulations now is pretty clear that you can move items. So I do believe that you are able to get a similar permit to move, even if it's not on a lease agreement or a sale, but you are returning to your family. So somebody that is in illegal occupation because he couldn't pay rent because the lease agreement was cancelled accordingly in terms of the provisions of the CPA or the Rental Housing Act, whatever the situation might be, that person can move prior to the 7th of June. And if he doesn't, he can be evicted.
Okay, fantastic. Then, so there's plenty of questions coming through, and thank you to everyone for asking these questions. This is exactly why the Property Law Alliance is here, to give guidance and clarity on all of these. Following this type of question, Silna, if the lease agreement has expired and the tenant couldn't move, but they are paying rent, can they and must they vacate at the end of May, even though they may not have found a new property?
Well, the thing is, depending on the lease agreement. So say, for instance, that lease agreement terminated, but the parties didn't do anything specific in terms of the Consumer Protection Act. So if the CPA does apply to the particular lease agreement, so it was entered into for a fixed term, and there was there is a natural person in the transaction, that lease agreement will continue on a month-to-month basis. If the tenant is happy and he's paying rent, the landlord is happy, my recommendation would be rather just reduce that month-to-month agreement to writing to ensure that everybody knows it's now a month-to-month agreement, and until the tenant can then move after the 7th of June when the regulations again allow for moving, then he can move to another property. So stay where you are if all the parties are happy, have the agreement on a month-to-month basis, rather have it in writing. The tenant that is in the premises and that's been wanting to move, but the regulations didn't allow him, will definitely be allowed to move prior to the 7th of June. Now, once again, on a new lease agreement concluded with a date reflecting prior to the 30th of April. So if he doesn't want to move and the landlord's happy, stay. Everybody is cool. We don't have to move. But if they want to move, now is the time.
So I think in summary, what you're basically saying is if the intentions of any of the parties before the lockdown ended were to actually vacate, move into somewhere else, even though there's not necessarily anything in writing at this moment, the reality is this provision allows us now to express and enact those intentions out. And that's the reality. So it's not about necessarily creating something new now, but it's about enacting something that was already there that you wanted to do, but you weren't able to do at that specific period of time. And that's, yeah, pretty much what we're advocating.
Yes, 100%.
Fantastic. Then another one is, why is the 30th of April specifically mentioned when we are still in lockdown? But they've said that only lease agreements enter into before the 30th of April. Solomon, maybe you could just explain, is there a specific definition of lockdown that
Yes.
maybe we can
Yes.
provide some clarity on this?
100%. So the original regulations that's dated the 26th of March does have a definition of lockdown, and the definition is specifically 2359, I kid you not, on the 26th of March until the 30th of April. So it's a defined term. So unfortunately, that's not us. And the reason why we're so on about the 30th of April is because of that definition. And I do believe the updated regulations with regards to moving, now referring to the lockdown, I do not believe necessarily that conclusion of a lease agreement, Bruno, as you rightly said, obviously, because it doesn't have to be in writing, the intention of the parties was to move to a specific property. The fact that we are recording it in writing after the defined lockdown period, as long as we date it as to the date when the parties came to an agreement, even verbally, or just reflect their true intentions. That's why we're so on about the 30th of April.
And I mean, like all of us know here, it's a standard practice in our law. Even when we deal with like property auctions, for example, with buying and selling, there's plenty of case law stating that the actual auction process might be oral in nature, but the actual recording of the auction process into a physical written agreement is enough to allow it to fall within the ambit of the Alienation of Land Act. That's the general principles. So the same thing applies here. Bottom line is, what was the intention of the parties? Was there a real agreement? Whatever you do after the fact is just a matter of recording it, of making sure that all the parties are on the same page. But if you picked up that phone and you stated your intention and the other person accepted it, and it was before the 30th of April, what's the problem? Like, that's
Exactly.
the agreement. That's the date that you said the agreement was entered into.
Especially if the parties then said, well, we can't sign that agreement now because we don't know if we can move. I agree with you 100%.
And most of these agreements you'd probably find didn't have any specified dates. So a lot of them would probably be, oh, when the lockdown's over, because no one knows what's happening. So because of the uncertainty, when lockdown's over, this directive kind of says, oh, well, it's technically for these reasons, it's over for these purposes. So those agreements would be able to be enforced or acted upon.
Yeah.
Great. Then another question here. I feel like it's quite an important question. Can a landlord turn off the centralized water heating, leaving tenants with cold water to bath? Would this not constitute spoliation and be a very, very, very bad thing to do?
Yes.
Silna, you are nodding quite profusely, so maybe you want to take this answer.
No, it's spoliation. And remember, because Regulation 19 refers to evictions, in terms of PI and in terms of ESTA, the honest truth is we've always had issues with arbitrary evictions. It's always been illegal. It's always been seen as an act of spoliation, and the landlord could have ended up with a bit of a slap on the wrist, potentially a horrible cost order in a spoliation application. Right now, guys, I am worried that that would be a contravention of the Disaster Management Act, and that is an actual crime now. So the landlord that got away with a few naughty cowboy tricks before the time, now is a real problem. So rather, if you have a problem with a tenant, call an eviction specialist. It's not really rocket science. If you are on this group, you have access to 3 firms of your choice. So rather get in contact with an attorney, get the right correspondence out, do the right things, follow the right process. I'm really not saying this because I'm trying to say, let's rather pay the eviction attorneys. I'm honestly saying this because I'm worried you're going to go to jail.
Yeah, absolutely.
Am I being
The implications are much worse than they would normally be.
And I mean, Silna mentioned the last time, the fact that it's illegal, like contrary to the actual regulations, means it's a crime now. as opposed to simply in the past where it was just a spoliation order. And I mean, the three of us have chatted about this before. People don't even realize ramifications. I've had cases where heart medication was left behind when people were locked out of a property, and that actually caused physical harm to the person that was locked out. Things like that happen. And when they do, and you landed up being the one that pulled that trigger, you're in trouble because you weren't allowed to do it. So it has nothing to do with trying to punt, do the eviction, just don't do the wrong thing. Go off on yourself, negotiate to get the guy out. Sure, by all means. Just, yeah, especially now under these regulations, because it is a crime and you're going to get into trouble.
Great. Then also, what are the measures that a body corporate or a homeowners association need to put in place to allow someone to move in and out? And can they implement restrictions? Are they allowed to implement restrictions for specific body corporates and homeowners associations? How can they? What can they do in this situation? Bruno, do you want to take this one?
So it's an interesting question because I've had this debate regarding body corporates for ages now, even before COVID-19. So for example, we've always had this issue of body corporates and Airbnb, and whether body corporates can restrict how owners let out premises, how owners interact with the tenants on their premises. So they try to control a relationship between owner and tenant. And whether body corporates are allowed to or not is a point in contention. And it has been a point in contention for the longest time now. So now we throw COVID into the mix and we say, well, is the body corporate now at this time allowed to control an owner and tenant's interactions and engagements because of COVID? Honestly, everyone has a different opinion. I don't feel it should be allowed unless it's reasonable, unless all the owners agree, and unless it's truly and there's a good justifiable reason for it. But with COVID, it's kind of difficult because that in itself might actually be a good justifiable reason. But on the other hand, if they put enough processes in place for safety processes, then there isn't a justifiable reason. So it's kind of a wishy-washy answer. I would probably say you could push the body corporate to allow movement, but there might be some resistance on some body corporates' parts.
Okay, fantastic. Then another question is this regulation. It's specifically saying place of residence. Does this regulation also apply to commercial tenants? Are commercial tenants allowed to move? Silna, do you want to answer this one?
No, it specifically says residence, so it's not even grey, it's pretty clear, black and white.
Black and white, quite straightforward. Then another question from one of our members. My tenant immigrated just prior to lockdown, but their possessions are still in the property. Will they be able to remove their possessions now for transport to Australia?
Sure.
It's quite a in-depth.
Greg, do you have an answer there? I think I agree with what.
So the question was, will they be able to remove their possessions to transport to Australia?
Yes.
Other than the fact that transporting to Australia is an old habit, it must be.
It must. And in terms of regulation 22.1F, let's just quickly check, guys. I'm going to share my screen. Where's my regulations now? No, I've lost it. I'm sorry. I'm not going to share my screen, don't stress. I just quickly want to see, I'm sorry now, I'm irritating everybody, but I think it's important enough to check, because regulation 22.1F unfortunately only deals with transport within the Republic. So I'm worried about moving it out of the Republic. That's what I'm checking.
That's a good point.
Yeah.
So
that's
Greg,
why, yeah.
I agreed with your nod until I thought about that, because they would be able to move it out of the premises, but whether they're going to take it over the water, I don't think so.
That's a secondary transaction. Obviously, that must wait for the ability to get on a boat. And well, there is some shipping going on, but who knows whether this is part of it. So look, certainly they can pack it up. Moving company can take it. Whether they can then get it on a boat to Australia, different story.
And I think the answer is, unfortunately, it's not going to go on the boat, because it specifically said transport of goods within the Republic. So Australia, unfortunately, guys, I don't know how to break this to you, is not within the Republic of South Africa.
Yeah.
Who knew?
Yeah.
So it's important. So definitely out of the premises, but no, I don't think it's going to go to Australia. Sorry.
You could probably force someone to move it into some sort of storage space. I think
Yes.
that would still be allowed. So especially if there's like rental being lost, storage space is going to be a lot cheaper. So that can be enforceable. But yeah, I have to agree. The Australia thing is going to be a problem.
Yeah.
Okay, then we've got a question. He would like to hear your views on whether you think the court will be in a position to grant an eviction order given the uncertainty of their legal occupier's position, financially or otherwise. How would we be able to plead all of this in an eviction application? What exactly is the stance here in order to get your eviction order, given that you have a tenant who can't afford to stay in the premises, can't afford another to rent anywhere else, they can't move. There's no other premises for them to move to. What would be the stance in getting your eviction order here?
Well, I think it's the same question. Sorry, carry on.
No, I wanted to say it's pretty much what I said earlier. So please do.
It'll be the same questions that are always asked if the situation arises. And I think there may be an element of greater sympathy of someone who's fallen on hard times as a direct result of losing their job now. But there are two things. The first is these questions are always asked by the courts anyway. If someone doesn't have money then to pay their rent, then it's not whether they can pay their rent, it's whether they can afford other alternative accommodation, or even as Silna said earlier on, move back in with family or whatever the case may be. As long as they have somewhere to go. The question will be asked because it always will be asked. And happily, all of our constitutional development has been around this very point for years. So we're probably way ahead of most jurisdictions on the subject. So I think it's situation normal. It can't be a defense. It's not a defense that you can't pay rent. The only relevant point is whether you would be homeless. And that, of course, depends on the particular circumstances. For someone to go from a conventional rent-paying person to potentially homeless is very unusual. The homeless, as jurisprudence appears to have unfolded, are a pretty vulnerable demographic. So there might be a backlog. Things might take a little longer. People might be given a little longer to vacate than historically, but other than that, we're way ahead of this curve, I think.
100%. And I think what's important to mention, Greg, you've mentioned people that will truly be left homeless. And I just want to add on to that, guys, remember, when somebody will be left homeless, it doesn't put an obligation on the landlord to provide him with alternative accommodation or anything. That obligation sits squarely on the municipality, thanks to our good friend, Mr. Vermaak, right here, and Blue Moonlight Properties. That was quite clear. It's a municipal obligation. The private landlord can never be compelled to provide alternative accommodation, but Greg, as you rightly said, the courts will probably allow people a bit longer to vacate than what we normally get.
Guys, I'm going to have to run. We've got a lot to go. Well, it's running.
No, I think
it's not running really.
We've got,
you know what I mean.
Yeah. We've got one more question. We did discuss it a bit earlier, but I think if we could just maybe get into a bit more. May we enter into lease agreements with new tenants now, after the 30th of April, provided tenants can move before the 7th of June? It will be devastating to our businesses if old tenants can move out, but new tenants cannot move in.
Don't answer that, anybody.
It's recorded.
That's our answer.
No, okay. No answer.
Teasing. Clearly, the intention is, on the face of it, not.
Okay, fantastic. Then I'm sure everyone has a busy day ahead, but we've got a lot of questions. Also, a lot of questions that have been asked that have been answered already in the beginning of the video. So please go back and rewatch. If you have any more questions, please pop them on the group. This is what we're here for, provide clarity to any issues that you have regarding the property industry and COVID-19 lockdown. But thank you very much, everybody. This has been a great video, and you've provided a lot of insight regarding this new regulation. And we will see you all a bit later next week for the Wednesday workshop.
Sure.
Thanks, Rowan.
Guys,
Thank you,
Fantastic.
guys.
Thank you so much, guys.
Cheers.
Bye-bye.
Thanks, guys. That was great.
Yeah.